They're online.
Here, first and foremost, good evening to all of you. First and foremost is we are going into the marriage laws. It is there are four marriage laws. One is called the Hindu Marriage Act of 1955. Another is called the Special Marriage Act of 1954, and then the third one is what is called the Indian Divorce Act of 2001. Because 2001 the act was amended, and the act was an old act of 1869 or 1879. It has been amended in 2001. As far as Hindu Marriage Act is concerned, it governs all Hindus and the marriages as far as Hindus are concerned. Special Marriage Act is concerned, it deals with intercaste marriages. Then, as far as the third marriage, that is Indian Divorce Act is concerned, it deals with what is called the law of divorce as far as Christians are concerned. Here, first and foremost is the earlier view taken was, or the earlier prevailing scenario was that the Family Courts Act was not there earlier. And the Family Courts Act was constituted very recently, somewhere in 2015 or 2016, but still some of the districts don't have family courts. Then earlier, we used to file all matters relating to matrimonial side on in the principal senior civil judge, who have the authority to decide all matters arising out of matrimonial disputes. Here, slowly what happened was they thought that the civil courts are quite burdened with heavy work, and therefore they passed the Family Courts Act, and all marriages today, be it Hindus, be it Christians, or be it the intercaste marriages, are governed by the family courts. Family courts are constituted almost in every city. For example, in Hyderabad, in Secunderabad, we have got two family courts. One called the Principal Family Court, and another is called the Additional Family Court. As far as Hyderabad is concerned, we have two or three family court now, principal family court, then first additional family court, second additional family court, and the third additional family court. Also, four courts are constituted in Hyderabad. And previously, the family court 4 was constituted in Nampally along with the criminal courts. But now it has been removed from the Nampally courts, and it has now been amalgamated or brought to Hyderabad. And please remember, Hyderabad, as far as family courts of Hyderabad are concerned, they are now not found in the civil court. Now they are shifted to the either to the service tribunal, that is the AP State Service Tribunal, and now it has all these courts have gone there into Purani Haveli. But as far as Rangareddy courts are concerned, there also we have got three districts which cover Rangareddy courts. As far as the principal Rangareddy court is concerned, we have got two or three family courts there which are constituted. And the senior most among them is the principal family court, and along with that, you have the additional family courts also. But again, the Medchal Malkajgiri district was carved out of the industrial area, or what was called in Urdu as the Atraf Balda. There we have got the Malkajgiri courts, which has got two family courts. One is the principal family court, that is the principal district judge and session judge of Medchal Malkajgiri district, located at Malkajgiri, and the second family court is constituted in Medchal, where the second additional district judge is the authority as far as the family courts is concerned. Then we have got one more additional family court in Malkajgiri called the first additional family court. Then in also, Kukatpalli also is part of Medchal Malkajgiri district. There we have got two family courts. One is called the principal family court, that is the principal district judge come family court, and then you have got what I think it is called principal family court number 3. And as far as additional family court also is concerned, that is normally earlier it was six additional district judge. Now it has been constituted as fourth additional district judge come what is called family courts. So family courts have been constituted almost in every place. But please remember, we have got family courts in Hyderabad, we have got family courts at Malkajgiri, we have got family courts at Mitchell, and we have got family courts at Kukatpalli. But here, if you see the periphery of Telangana, you got the family court constituted in Sangareddy. Now, Sangareddy, I think most of you know, has been bifurcated. Sangareddy district has become separate, and Medak district has become separate. Medak district has got the headquarters at Medak. And as far as Sangareddy courts are concerned, it has got the headquarters at Sangareddy. In Sangareddy, there is one family court. There is only one family court constituted. It is called the Fifth Additional District Judge Cum Family Court. And Mehboob Nagar still doesn't have a family court. And Khammam, you've got a family court. Then you've got in Adilabad, you've got a family court. And then you have got family courts in almost every place, barring few places. Then, when family courts are not existing, then in that case, all the matrimonial matters have to be filed before the principal senior civil judge. And normally, all the cases which are filed before either two was numbered as OP. OP means original petition. It is not a suit, please. But here a distinction has to be made. If it's a dispute relating to Muslims, it is not numbered as OP, it is numbered as OS. And after the family courts were constituted, all the matrimonial matters were numbered as FCOP, that is Family Court Original Petition on the matrimonial side. And any appeal that is filed against a decree passed by a family court, then appeal rise to the High Court and it is called FCMA. FCMA means Family Civil Miscellaneous Appeal. And normally, as far as the High Court is concerned, under the Family Courts Act, any decree against which an appeal is filed is heard by a division bench. Division bench means two judges will have to constitute a quorum as far as hearing an appeal against the decree of a family court. Then the question arises, sir, what is the jurisdiction of a family court? As far as family court is concerned, family court decides all disputes not only relating to the matrimonial matters, but they decide matters even concerning the family. One example I can give you: once, let us say, the deceased dies, there is a dispute between the two wives as to who the legally wedded wife is there. And a suit that has and a claim that has been made in a family court is normally filed in the form of what is called uh, what is called a FCOP. There also the court decides as to who the legally wedded wife is, whether it is A or whether it is B. Then all matters concerning the family, all disputes concerning the family, if it comes within the definition of the word family, then you cannot go to a civil court. Section 9 of the Civil Procedure Code applies. All suits of civil nature can be filed in a civil court unless expressly barred. Then, sir, after the family courts are constituted, you cannot go to a civil court, but you have to go to the family court. Then the question arises, sir, are you given a direct entry as an advocate before the family court? But please remember, when the Family Courts Act was passed, they painted the advocates in a very wrong shape, saying that the advocates are the villains. They don't allow family court matters to be decided or disposed of immediately. So they barred the advocates. They don't have a direct entry as far as family courts are concerned. But experience shows that the persons who are the parties, be it the wife or be it the husband, they do not understand the legal jargon and how a petition has to be filed before the family court. And they require legal assistance, and they cannot lead evidence by themselves, or they cannot conduct cross examination by themselves, or they cannot argue a matter by themselves. However qualified you may be, however technical skill you may have, but still you lack in experience in conducting family court matters. So for that, there is a provision made in the family courts to say section 13. And suppose a party wants legal assistance and he wants to be assisted by a legal counsel, and he says that I do not know the legal jargon, I do not know how to file a case, I do not know how to conduct the case, I do not know how to prosecute the case, I do not know how to defend the case, I do not know how to cross examine a witness, I do not know who are the witnesses who are necessary to prove my case, and what are the sections which govern the grievances before a family court. So, for that, a legal expert is required, and that is the reason
why Section 13 of the Family Codes has been enacted, whereby they say that the party can file what is called a petition under Section 13 of the Family Codes Act for permission to be represented by a legal counsel. And the wakalat of the advocate also has to be filed to show that he is going to represent the party as the agent of the party. But please bear one thing in mind, though you are the advocate for the party, though the permission has been granted by the court, all petitions and all OPs have to be signed by the party alone. You are only an amicus curiae. You are only the amicus curiae. The meaning of that is you are only the friend of the court. You are only assisting the court. You are only prosecuting a case on behalf of a party, and you are defending a case on behalf of a party. Please remember, more than that, you cannot have any more powers. And here, whenever you file a petition before the family court, it is safer that you take the signature of the party and, as far as possible, avoid signing any petitions, avoid signing any FCOP, because you don't have a direct entry as far as family courts are concerned. But when FCMA is filed in the High Court against a decree passed by the Family Court, then of course you can file your wakalat. There is Section 13 does not apply as far as High Court is concerned. In the High Court, you can file the appeal as an advocate. You are not the amicus curiae as laid down in Section 13 of the Family Courts Act. These are all the intricacies or complications as far as the family courts are concerned. Please bear one thing in mind, sir, as far as legal knowledge is concerned, applicability of the sections are concerned, what is the relief you have to claim, under what provision you have to come, what is the court fee you have to pay, how a OP has to be drafted, all these things are known only to an advocate and not to a party. Please remember, you may ask me one question, sir. Suppose one, of course, God forbid, one of the parties is an advocate. He can file it himself, isn't it? There is absolutely no bar, sir. A party in person also can file. But please remember, a party does not, even if you are an advocate, when it involves a personal matter, you get emotional, you get impulsive, and you do not know what to do and what not to do. And please remember, in that case, it is advisable to file a petition under Section 13 of the Family Courts Act, seek the permission of the court to act as the amicus curiae or the friend of the court to prosecute or defend the proceedings for and on behalf of the party. Yes? Then all proceedings under the family court are all special proceedings. It is not a civil court. Bear one thing in mind, sir. A family court is not a civil court. A family court is a separate tribunal constituted for the purpose of deciding and deciphering and also giving a verdict regarding the respective parties as far as the matrimonial dispute or matters relating to the family is concerned. And one more thing I would like to point out, sir. One of the cases filed by the admins here in the Vijayawada court is that an FCOP was filed by the wife against the husband, and the additional family court in Vijayawada, an application also was filed asking for what is called furnishing of security to the extent of 90, I think it's 90 lakhs. 90 lakhs. Then, in that, what happened was the court sitting at Vijayawada attached a property situated at Elladiguda Amirpet, and the husband was asked to furnish security to the extent of 90 lakhs. Then what happened was one of the clients of my admin was the purchaser of the entire third floor and nearly measuring about 4,500 square feet. Then the question arose whether the order can be passed by a court sitting at Vijayawada and attach a property at Hyderabad. Here, the question that arises is the husband, as usual, did not furnish security, and the property belonging to the husband was attached by the family court in a particular interlocutory application. Then the question arose, we filed an application on behalf of the third party, that is one of the leading accountants, like leading chartered accountant. I don't want to give the name. To say that I want to get implemented only in the IA as far as furnishing security is concerned, and I also want to set aside the attachment issued against that property. I am only concerned with the third floor, and the order passed by this court is 1 year later than my purchase. The regular sale deed also was filed. The linked documents also were filed. And along with that, a suit also was filed before the second senior civil judge, Hyderabad, for declaration that the order passed by the Honorable Family Court was null and void, and the Family Court was not authorized to pass an order regarding a property that is located in Amirpet, Ella Rediguda. It was two proceedings that were initiated. Of course, as you know, rigmaroles of litigation. We almost, I think, myself and the admins, we traveled about 10 to 12 times to the additional family court, and sometimes the court is on leave, sometimes the matter is urgent even before we reach the place. And one fine day, we said, sir, we are insisting on the petition for impleading to be argued. Then I told the court, sir, there are two provisions in the Civil Procedural Code. We are also governed by the Civil Procedural Code. One is called Section 46 and Section 136. 46 deals with what is called precepts, Precepts. What do you mean by a precept? Letter of request from one court to another court to do a particular thing on its behalf and file the report before this court. Then a letter has to be addressed to the principal district judge, the principal chief judge, City Civil Court, Hyderabad, to do that job for the Vijayawada court. And the bailiff of the Hyderabad court has to be deputed to attach the property. In this case, what happened was the court sitting at Vijayawada attached the property which is beyond its jurisdiction, and and that property at Amirpet was attached by the court sitting at Vijayawada. The legal part, then there is one more section called 136. 136 is whenever attachment proceedings are challenged, the question is whether the court had power, the court had authority, or the court went beyond its power has to be discussed. Then, of course, that attachment petition is still pending. But as far as the impleading petition is concerned, the defense taken by the other side, as far as the interlocutory application is concerned, was to say that the entire complex at Ellaredi Guda was constructed out of the dowry amount of 1 crore given by the lady to the husband. And that money was spent for the purpose of constructing that complex. And she also said she is part of the Koparsonady, and it's an ancestral property, and she has got a share in that property. But the question here arises, sir, a wife can never be a co-partner. Please bear that in mind. Hindu law, only the male is a co-partner. Male means in the sense husband is a co-partner, but the wife is not a co-partner as defined under the Hindu law. That is one point. Second point is whether the court was justified in ordering security to be furnished and also attach the property sitting at Vijayawada, whether the provisions of Section 146 and Section 136 of the Civil Procedural Code was followed or not. Here the question arises, it is not a money suit. It is a suit for divorce on the ground of mental cruelty. What are the issues involved, sir? Whether the husband was guilty of mental cruelty or not. That is the only issue that is involved. But as far as the money which she claims, or to have a charge, or to furnish security to the extent of 90 lakhs is in the form of an alimony. Alimony is granted in marriage matters under Section 25 only after a decree is passed, not earlier. That is one of the legal points raised. So the question is, court prejudged the matter as if it's a money suit and ordered security to be furnished. Number one. Second thing is, it attached a property over which it had no jurisdiction to do it because the property was not located in Vijayawada. It was located at Amirpet, that is within the jurisdiction of the City Civil Court, Hyderabad. Then, on the ground of impleading, she impleaded the third part. I said, I'm not concerned with the interstate dispute regarding the family court, regarding the divorce. I am only a party attacking the attachment orders. Right? The question is, my purchase has been made 1 year earlier to the order passed by the court. Number one. Number two, whether the court has to decide whether it's a money suit or whether it's a matrimonial proceeding. If it's a money suit, of course, I agree. Order 38, Rule 4 and 5 provides conditional attachment. Party can be directed to furnish security. But if it is a family court matter, 90 lakhs is not in the form of a recovery of money. It is in the form of recovery of alimony. Alimony under the Hindu Marriage Act under section 25 is recoverable only after the decree is passed, not otherwise. And when that lady takes a stand, I have spent 1 crore for, I invested 1 crore for developing that property. It is not a ground, and she's not a Kopasna, and that was not pleaded in the counter. What I'm trying to tell you is what all defenses you have to take, what all grounds of defense you have to take, which might or ought to have been taken. If you do not take it, it will be exploited by the other side. So in that case, what happened was now the real game starts. Now the party has been implemented. Not only FCOP, we are not concerned interstate disputes between the wife and the husband. We are only concerned whether the attachment regarding my property has to be raised or not. That is the only issue now involved. And second thing is, sir, it's an ancestral property. As far as an ancestral property is concerned, perhaps you may jump to the conclusion, sir, 29A of the Hindu Marriage Act, 29A of the Hindu Succession Act has been introduced by the Amending Act of 2005. A female heir also gets a right as far as ancestral property is concerned. But please remember, this lady is a lady from outside the family. She has come into the family and she claims herself as a co-partner. A wife cannot be a co-partner. Please bear that in mind. I just take you to one of the provisions of the Hindu Succession Act also, section 23. There they say, as far as the dwelling house is concerned, a wife is not entitled for residence. Wife is not entitled for any right in respect of a dwelling house. That is section 23 of the Hindu Succession Act. So all these points are there. What you have to do is you have to cleverly draft a matter which appeals to the court, even if a judge does not know the law. You have to educate the judge. Sir, this is the position of law. This is how it has to be decided, and this is how you have committed a mistake by ordering the attachment. The judge was a bit peeved. She said, "Do you think that I passed the wrong order?" Sir, I'm not saying for a moment that you have passed a wrong order. Only thing I say that you have been misled by the opposite side. Of course, my admins were laughing. They said, "Sir, you are trying to twist words and try to say something than what you have said it earlier." Then the judge said, "Sir, Mr. Gentleman, don't think that I have not noted it. I have noted every point what you have reached. You said I passed a wrong judgment. Sir, I still stick on to that. It is contrary to law what has been passed." Then I do not know within 3 days the order was passed, pleading question was allowed, setting aside attachment. What I'm trying to tell you is, please remember sometimes, but when you have to twist matters, alimony, it's not a money suit, bear it in mind. If it's a money suit, I agree. Conditional attachment can be ordered, and party can be directed to furnish security also, I agree. But the question is, it's not a money suit, it's a matter under the FC. That is family court. When it's the interstate dispute, the husband and wife, the question is alimony becomes payable only after the decree for divorce is passed under section 25, not earlier. Are you able to follow, please? So this is a practical experience which myself and my admins had, and it's a case of my admins. The question is, it's a case of a leading chartered accountant. I don't want to give the name, but the question is, sometimes we have to twist matters. Sometimes you must make the judge understand what you have done is wrong. Please try to rectify it now. Please remember, without hurting the judge, without insulting the judge, without annoying the judge, you can persuade the judge to say, "Sir, please remember, you have been misled by the other side. You are not at fault, but you have misinterpreted the legal provisions." Right? So this is one of the experiences which we have in the real practice. Then one more matter, sir. The question is, there is a dispute between the first wife and second wife. In Telugu, they say Savatigola. When the Savatigola starts, sir, Savatigola starts only after the death of the deceased. Husband is entitled for terminal benefits. The husband's legal heirs are entitled for what is called a job on compassionate grounds. Husband is also entitled for the legal heirs are also entitled for what is called family pension and other benefits. Here, the real dispute starts between the first wife and the second wife. But unfortunately, there is a judgment of the Supreme Court that though monogamy is only permissible under the Hindu law, still a person can have two wives, and that was regarding northeastern states. There is a custom in the northeastern states: a person takes more than two wives. The question is, so long as they co-live, so long as they have a unity among themselves, so long as they don't have fissures, so long as they don't have differences, there's no problem at all. But real problem starts, they are not bothered about the death of the deceased. They are only bothered about how to share the spoils of the service which the disease has rendered. Then in that case, sir, one cardinal rule of Hindu law is once the first wife is once the first marriage is subsisting, it has not been dissolved, it has not been divorced. Then in that case, the first marriage alone is legal, but the second marriage which takes place during the subsistence of the earlier marriage, the second marriage is void, and the second wife cannot be called as a legally wedded wife. But the Supreme Court has interpreted this position by saying, suppose there are offsprings from the second wife. The question is the offspring, though they may be illegitimate because the wife or the mother is illegitimate, they are also entitled for a share as far as the father's property is concerned. But if both of them are have an understanding, you take the job, I take the terminal benefits, or both of us will share equally, then in that case, there's no problem at all. That's why I said, Mia Bibi Razi hai to kya karega Kazi? It's not Mia Bibi here. Bibi Razi hai to kya karega Kazi? Court also is helpless. And they said, you share it half half. Sometimes the problem really arises. Sometimes they say that a person has more attachment to the second wife rather than the first wife. The question is తర్వాత వచ్చిన దానికి మర్యాద ఉంటుంది రెస్పెక్ట్ ఉంటుంది కానీ మొదటి ఉండేది పాతది అయిపోతుంది జస్ట్ డూ ఇట్ దట్స్ వాట్ ఇస్ ది యాటిట్యూడ్ ఆఫ్ మోస్ట్ ఆఫ్ ద మేల్స్ దట్ ఇస్ వాట్ ఇస్ కాల్డ్ మేల్ షావనిజం హియర్ as far as the disease is concerned he has nominated as his second wife as the nominee. Then how the amounts have to be dispersed according to the law relating to disbursement of amount. The benefits has to be given to the nominee alone. But if you see, when our marriage itself is illegal, when our marriage itself is unlawful, how can she get that money? The question is normally it has to go to the first wife. Then suppose there is a dispute regarding that, who is the first wife and who is the second wife, whether the earlier marriage was subsisting or not, whether the earlier marriage was dissolved or not, whether the earlier marriage ended in a divorce or not, these things has to be decided by a family court, right? Then the question is, suppose they enter into an out of court settlement, they want to share it half up, no problem at all. But if the nomination is there, the question is what would happen to the nomination? Normally, the authorities will pay according to the nomination. But if you see the Hindu law of succession, the question is the first wife he comes under class one. She is a class one here. When she is available, where is the question of giving the money to the second wife? Though it may be a nomination, still court under exceptional circumstances, following the general law of succession, can grant the money to the first wife. So it is better in such cases if you are the advocate for the second wife, advise your client, sir, don't fight all this litigation and all. You share half up, or you take the compassionate appointment. Your children will take your compassionate appointment, and as far as benefits are concerned, let the wife get it. Of course, it's a far-reaching question, sir. Which lady will agree to take half off? She will say, I am the legally wedded. ఈమె ఎప్పుడు వెళ్ళిపోయింది ఈమె దారియే తెలియదు. I am the person who has looked after the disease. I am the person who has attended the hospital. I am the person who spent the money for his medicines. I am the person who gave him physical comfort. I am the person who gave him mental comfort. I am the person during convalescing period I nursed my husband. So on and so forth. I got lot of love and affection for my husband. My husband, out of love and affection, has nominated me as his nominee. So the question is, I am only entitled. But it depends on how the court interprets it. Normally, if you ask me, under the general law, the first wife alone is entitled. The second wife during the subsistence of the earlier marriage, provided, of course, I'm saying, if the first marriage is true, then in that case, she alone is entitled, irrespective of the nomination. Then, as far as nomination is concerned, sir, of course, at the time when a particular suit came up, the family courts was not existing. At that time, the mother of the deceased brought an action against the daughter-in-law, claiming and also the State Bank of India was made a party and claiming the terminal benefits. And she also alleged that she is a class one here, as laid down in Section 8 of the Hindu Succession Act, and the bank committed a mistake in paying the money to the widow. But earlier, before marriage, the nomination was in the name of the mother. Subsequently, after marriage, the nomination got changed and it was changed in the name of the nominee, that is the wife. It so happened that the lady, after the death of her husband, she married a second time. And she also got a job in the State Bank of India on compassionate grounds. This irritated the mother. The mother filed a suit for recovering half the money that was paid by the bank. And she also alleged that she is one of the class 1 heads as laid down in Section 8 of the Hindu Succession Act, and the bank had committed a mistake in making the payment to the wife alone. Then, unfortunately, what happened was I was the advocate appearing for the bank. I asked for a book that is as far as the Provident Fund rules or the terminal benefits rules are concerned. What is the definition of the word family? In the State Bank of India's regulations, as far as the retirement benefits is concerned, the word family has been defined as spouse or spouses and children. Mother is eliminated. Mother is not the successor. But there they said a man acquires everything by birth, but what he does not acquire is a spouse or children. So the spouse and children come later, and even if a nomination is there in the name of the mother prior to the marriage of the deceased, it gets wiped out, and the wife steps into the shoes of the nominee, and she is entitled for the benefit. Of course, the matter went up to the High Court. Ultimately, the mother did not succeed. So this is how things happen, sir. All these matters, of course, at that time, I think if I'm correct, it is 73 or 74, there the family court didn't exist. Now, if the family court has to decide that matter, they have to go purely by the letter and spirit of the law by saying that who is a person coming within the definition of the word family. They say even if a nomination is the name of the mother, subsequently a person acquiring the family, the spouse or spouses and the children alone come within the definition of the word family, and the money becomes payable to the family alone and not to the mother. This is the present law. So this is as far as the various cases or various examples I can cite for the purpose of understanding the matrimonial law. Yeah, matrimonial law, please remember the first and fundamental principle is a Hindu marriage is supposed to be a sacrament and a Muslim marriage is supposed to be a contract. What do you mean by sacrament and what do you mean by contract? Here, Supreme Court has interpreted how a marriage is valid. The Supreme Court earlier said that as far as the rituals of Hindu marriage is concerned, and that is what is called uh, Gauri Vratam. The bride performs the Gauri Vratam, and after the Kashi Yatra takes place, and after that the bridegroom gets irritated and goes outside with an umbrella. The father of the girl comes and begs the would-be son-in-law to say, "Why are you becoming a sannyasi at this young age? I'm giving my daughter in gift to you in Kanyadanam. Please accept my daughter as your better half." Then the son-in-law gets cooled off. Then he comes and sits in the pandal. And I think I was discussing this with one of my lady juniors, who is also one of the admins here, to say in Telugu marriages I've seen, they put a parda. Even if you see Srinivasa Kalyanam or the Venkateswara Kalyanam, a screen is put where the boy does not see the girl and girl does not see the boy. And ultimately, when some mantras are decided, then the screen is removed. The husband can see the wife can see the husband. So the question is after that, what happens is a yoke is put on the head of the girl, head of the bride, and the husband takes a oath saying that till now we were separate beings, and now from now onwards we are yoked as a double bull to plow the field of samsara. And in the times of happiness, in the times of sorrow, in the times of plenty, in the times of nothing, we shall not forsake each other, and we live throughout our life so long as the life exists. As Ram and Sita, they were the ideal couple in my college, and we shall not forsake each other. But how far it's implemented, it's a history. The question is then after that, the tying of Mangala Sutra is done. That is the holy thread is tied on the bride's neck, and the three knots are put. I don't want to tell you because I don't know the significance of the three knots. Then after that, what happens is the husband gets hold of the finger of the girl and they perform the seven steps. They go about 7 steps across the holy fire and take a oath before the God Agni to say in times of plenty, in times of happiness, in times of nothing, in times of sorrow, in times of difficulties, in spite of in spite of plenty, we will live together. We will not forsake each other. We will throughout our life, so long as our lives exist. And then The Supreme Court earlier interpreted, saying, sir, how when is a Hindu marriage complete? They said Hindu marriage is complete when the Mangala Sutram is tied, Kanyadanam is done, and after that the Mangala Sutram is tied across the bride's neck. That finishes the marriage. But latest Supreme Court, I think if I'm correct, 2022 or 2023, which says unless Saptapati is performed and seven steps are taken across the holy fire, propitiating the god Agni, the question of a Hindu marriage is not complete. Then the question arises, sir, why is it a sacrament? It is called a sacrament because we cite the example of Ram and Sita who lived together, except for that separation when Ravana abducted Sita from her home and kept her in his custody. Of course, I don't want to go into that mythology. The question is, that means even in spite of difficulties, they live together because they are the original God, that is Vishnu and Mahalakshmi. Then the question arises, sir, so so long as there is no dispute, there is no problem at all. Supreme Court said performance of Saptapati is absolutely must compulsory. Then please remember, India is a country of really have different castes, different subsects, different denominations, different customs, different usages, and different usages in different places in different parts of India. Then the question is whether the custom will override the law. Here, please remember, here they say sometimes what is happening. That's why they say they evolved the doctrine called doctrine of factum valet. Factum valet means even though all the rituals of the marriage is not performed, law presumes a valid marriage provided it is recognized in the custom, it is coming from time to time, followed by the people belonging to that particular community. Then the question is, even though all the rituals are not followed, the courts presume a lawful marriage between the husband and wife. Then, of course, my admins will be laughing at me when I give that example of Chira Ravika marriage. The question is in Chikatpalli, that's the only place where this marriage is performed, and this is performed only regarding the Lingayat community belonging to Karnataka. The question is here, what they do is the husband presents six saris and six wearing apparel to the wife, and before the god, they propitiate, and the priest pronounces them as husband and wife, and then issues a marriage certificate. Then people are fed as far as the feast is concerned, and the marriage certificate is granted by that particular institution or particular temple. Then Yadgiri Gupta also the same type of customs are followed. The question is even there the marriage certificate is issued. Then the Arya Samaj marriage. Arya Samaj marriage, please bear it in mind, it is not under the Hindu Marriage Act, but it is under the Special Marriage Act. Arya Samaj, you can belong to any community. You need not get yourself converted. But 1 month's notice has to be given so that if anyone has got objections for the marriage between the spouses, the question is the objections will be heard and the marriage will not be performed. But if no objections are received within a 1 month period, marriage is registered under the provisions of the Special Marriage Act, 1954. Then one more introduction I would like to give you is the marriage as far as Christians are concerned. As far as Christians are concerned, previously we had the earlier enactment called 1879 Christian Marriages Act. Under that Christian Marriages Act or the Indian Divorce Act, as it was called, it was only on paper it was called Indian Divorce Act. But getting a divorce earlier in Christians was very, very difficult. That is only on two or three grounds you can get the divorce. One was on the ground of adultery, that is living with some other woman, forsaking your lawfully wedded wife. Second one is change of religion from one religion to another religion. Third one is when the boy is suffering from what is called a virulent disease like AIDS, VD, venereal disease as they call it, or an incurable disease, or is impotent and incapable of having children. All these grounds were there under the Indian Divorce Act as it was in 1879 or 1889. But what happened was there was a clamor among the Christians that why is it called Indian Divorce Act? Please remember to maintain a petition for divorce under the old act was very, very difficult. Why? Because Adultery. I'll take one example of adultery. Adultery is a person living in illicit intimacy with another woman and breaking the vows of marriage. It's called adultery. Then, when you file a petition for adultery, you must not only make your wife a party, but you must also make the paramour a party to the proceedings. It is very, very difficult, sir. Nowadays, those days we didn't have CCTVs and all. Now everything is there. Unfortunately, what is happening is the net is spoiling the privacy of the spouses. Even what they talk, how they fight, and what are the skirmishes between them are also found in the CCTV. Absolutely, there is no privacy in the room. But what happened was the Christians revolted and said, "Sir, why should Hindus be given preference? We should also be given preference." And they wanted the amendment of the Indian Divorce Act. Today, what all provisions are available for divorce under the Hindu Marriage Act are also available by the Amending Act of 2001. It's now called the Indian Divorce Act of 2001. 1899 or 1879, as amended in 2001, on the grounds which are available to you under the Hindu Marriage Act, is equally available today as far as Christians are concerned. So, this is the introduction as far as the three types of acts are concerned. One is Hindu Marriage Act, another is called the Special Marriage Act, and another is called the Indian Divorce Act. So, with this introduction, we go to the subject in the proper perspective. Here, as far as the Hindu Marriage Act is concerned, it was an enactment passed in 1955. Here, first and foremost is section first four sections you can avoid this. As far as the section 2 is concerned, the different definitions are given there. What is prohibited relationship? What do you mean by sapinda? What do you mean by spouse? What do you mean by wedlock? So on and so forth. That I think most of you, I think some of you, I don't know, all of you must have been married by this time. So the question is, you know the various terms that are used in the Hindu Shastras. That we need not dilate about it. But here, the first and foremost condition is on the date of marriage, when the man and woman come together, the question is one person should not have a spouse living. That means you can, without the first marriage being dissolved or divorced, the question is the second marriage cannot take place. So the first condition that is imposed is conditions for marriage is you must not have a spouse living or you must not have got married at all. That is, in other words, you must be a bachelor, and it also applies to the other side also. The other side must be a spinster or a maiden. Second one is neither party is incapable of giving valid consent because of mental disorder. Here, because of unsoundness of mind. Please remember in Hindi they say diwana or diwani or pichodu pichidi. Here, what do you mean is when your mental faculties are absent. Please remember, అంటే the question is any consent is given. ఈ అబ్బాయిని పెళ్లి చేసుకుంటా నాకు పెళ్లి అంటే చాలా ఇష్టం. The question is whether she really talks from her senses or she's talking out of her senses. She does not know what she is talking because she is suffering from a bout of mental insanity or mental unsoundness. Then, in that case, if one of the parties is unsound or suffering from insanity or lunacy, then in that case, a marriage cannot be done. The third one is mental disorder. Of course, this mental disorder has got different connotations and different meanings, sir. Sometimes what happens is certain tragedies occur in our life. We go into a bout of depression. We develop a distaste for everything. We feel that in Telugu, I think in Devadas, there's a Jagame, Maya, and all, you start singing. Then in that case, something is wrong with your brain. Then in that case, you are suffering from a bout of mental disorder which has been certified. Then please remember, no person will marry a person, whether it a male or a female, who suffers from mental disorder due to various reasons, please. Please remember, I'm not for a moment saying they're all unfortunate people. Sometimes what happens is there is a court litigation. I mean, the most of the cases mental disorder takes place is in a court case. Suppose you fight it as a prestige issue, you lose the case, you go into a depression, or you have divana ho jati. That is, you become a mentally unsound person. Or let us say you lose your wife with whom you have got or you lose a person with whom you are fully attached, like your father or mother or brother.
Then in that case, what happens is you go into a boot of mental disorder. Then please remember, a mental disorder, the question is, it's a disqualification for a valid marriage. Then the fourth one is recurring attacks of insanity. Here in this case, of course, please remember, I don't think there is a person with a turban. The question is, please remember, we make fun of a particular community person by saying Barabaje and all. There, the question is not that. Please remember, the hard-working people are from the Sikh community only. And as far as England is concerned, the Irish and Scottish drummers, they say they have boots of insanity. Boots of insanity is what they do, what they are supposed to do. They do not know anything about it, and every 1 hour or every half an hour they get these boosts of insanity. Then they act like a mental person. And one of the instances I can give you of mental insanity is drug addicts, especially. Please remember, the worst enemy for a drug addict is the worst enemy for a mother or father is the son who is addicted to drugs. Drugs is the most dangerous and dangerous element which destroys a family. And a person who suffers from boots of insanity under the influence of drugs, the question is, he is not qualified to get married. Please remember, it will be a curse on you if you get such a person married to a girl and slit her throat. So the person who suffers from mental insanity during intervals, then that person is not qualified. Then please remember, now one restriction has been imposed in the name of family planning. Here, as far as the male is concerned, he cannot get married before attaining the age of 21 years. A male cannot get married unless he attains the age of 21 years. As far as a female is concerned, she cannot marry unless and until she attains the age of 18 years. Sir, why this is provided, sir? This is provided because the question of sanity or otherwise, or adjustability, compatibility, or adapting to the married life, or adapting to the practice of getting children. A person who has just attained puberty, if she gets married, she may not all know all these things. So the question is, let her understand the world. Let us understand the worldly pleasures. Let us understand what marriage is. What is the importance of marriage? That is the reason it is said a male cannot be married before attaining the age of 21 years. And as far as female is concerned, she cannot get married unless she attains the age of 18 years. And then we got to what is called last one is prohibited relationship. What do you mean by prohibited relationship? They are called what is called consanguine marriages. Consanguine marriages means 3 degrees from the father side and 5 degrees from the mother side. That is, you cannot marry. I'm talking about Hindus, this, not about Muslims and all. As far as Hindus are concerned, if they belong to the same blood, that is, for example, suppose you have 4 brothers, and let us say your son wants to marry your younger brother's daughter. Here, there's a blood relationship between the parents. They are brothers. Naturally, they are of the same blood. If they are of the same blood, the question is there cannot be consanguine marriages. But you have seen the real experience among Hindus, a, a boy from a boy born to a brother gets married to his sister's, I mean, to the aunt's daughter. Here we say we make an exception, saying that when the girl goes out of your family, gets married to someone else, she goes into the other Vamsha. And the children which are born to her do not belong to your Vamsa rather, or your, then in that case, the question is marriages should not be done. And please remember, we have seen people who get married in prohibited relationship, their children are born deformed, children lose their eyesight, children don't have ears, children suffer from physical ailments and all. That is the reason it is said. And as far as the mother side is concerned, 5 degrees on the mother side. But as far as Muslims are concerned, I have to make a mention about it also. As far as a Muslim is concerned, a Muslim boy cannot marry his aunt's daughter, or a aunt's daughter cannot marry her maternal uncle's son. But they can marry. Suppose A is there. A's son can get married to his brother's daughter, that is B's daughter. But I do not know it is permitted. They say they can do that, but they cannot marry within prohibited relationship. But in Andhra area, especially, we find
Menamamal, that is maternal uncles are normally, in Hindi there is a joke, they say Sali Adi Garwali. But here I would just try to interpret by saying Sala Ada Garwala. That means the brother-in-law is brought up as a son in the family and he has got the first choice to marry his sister's daughter. This is done regarding Andhra area only. I do not know about Telangana. Here, Telangana is not prevalent, but in Andhra area, that is Menamamani Cheskuntaranmata. The question is, it's not a prohibited relationship because the question is your Menamama or your maternal uncle does not belong to your blood. He is outside the blood. Then we come to the half blood. What do you mean by half blood? That is one of the definitions given. Half blood means where it is born of the same uterus, but of different fathers. That's called uterine. And that is what is called half blood. Half blood means born of the same uterus, but of different husbands. Then, in that case, also, perhaps they come within the prohibited relationship. Please remember, these are all things not made by law. These are all things recognized by the Shastras. They are all recognized by the Manusmriti, or they are made for the goodness of a person. And then another thing also you must remember, Sapinda. What do you mean by Sapinda? Under the Hindu law, Sapinda means a person and a Palol antaru చూడండి మీ తెలుగులో. That means a person who belongs to the same family. Suppose, let us say, you don't have a son, your brother's son performs a ceremony and he lifts the holy fire. He is called a Sapinda. He belongs to the same Pinda and he is called a Sapinda. And you cannot marry a Sapinda. That means your same generation, you cannot get married. That's one of the prohibited relationship that is contemplated under the law. Then, sir, the ceremonies, I have also given you an introduction regarding the ceremonies. First and foremost is section 7 says the valid ceremonies that have to be performed, like what is called performance of the Gauri Vratam. By Telugu people follow it. Vinayaka Stuti has to be done before the marriage is commenced. Then after that, it follows. Next thing is Kashi Yatra. That is, the boy goes with an umbrella, and the father of the girl begs the son-in-law, "Don't get angry. Don't become a sannyasi. Please take my daughter as your better half. I am giving my daughter as a gift to you. I am going to perform kanyadanam." Then the boy comes back. Then they sit. And Telugu marriage, I've seen a screen is put, and after that the kanyadanam takes place. And after the kanyadanam, the question is Mangala Sutram is tied, and across the holy fire, they take 7 steps and take a oath before the Lord Agni that they will live together throughout like Ram and Sita, and then Appagintol, then the Gro Pravesham as it's called. The girl enters the boy's house, and the question is, uh, then the question is the parents of the girl hand over the girl to the boy's family, and then after that the girl goes out to the family, so on and so forth. These are all the ceremonies which are followed. Of course, the question is, it is also followed by nuptials. Of course, I don't want to give the full meaning. It means consummation of the marriage, where the husband and wife come together for the first time. But here also, we believe in looking at the stars, looking at an auspicious day, and on that day, the consummation takes place. But please remember, under the Hindu law, consummation is not compulsory. But under the Muslim law, of course, consummation is absolutely mandatory. Then next one is the registration. Now in 2015, they introduced a new law by saying Section 8 says that every marriage has to be compulsorily registered under the provisions of the Act. Why? Because they will be recognized as husband and wife. It is prima facie proof of A and B being the lawfully wedded spouses. And please remember, when you apply for a passport or when you apply for a visa and you want to take your wife to a foreign country, then in that case, unless the marriage is registered, the question is valid marriage will not be presumed. Then what are the essentials of a registration, sir? You have to you have to have that invitation card. You have to have your marriage photo. Then along that, you have to fill up the application and also fill up the various blanks there. And your marriage is registered, and the registration certificate is given by the registrar. Then the question of course, the next section is, of course, I discussed, I gave an introduction, restitution of conjugal rights. Before going to that, I will discuss a leading case on that aspect. There is a famous case of the cine artist Sarita that was decided by our High Court, the composite Andhra Pradesh High Court at that time, Sarita versus Venkata Subbaiah. the validity or legality of Section 9 of the Hindu Marriage Act was challenged in the Honorable High Court. And Sarita was the petitioner, and Venkata Subbaya, of course, I'm saying our first, our husband, only husband, rather, I put it that way. He was the respondent. Then the point that was urged is we are not cattle. We are not cattle to be flocked together and then taken to a institution called marriage. And I cannot, ante ఏమంటారంటే తెలుగులో నేను నా మొగుడికి నేను బానిస కాదు. I am only the better half. The question is, both of us have developed differences and incompatible differences, and our differences cannot be patched up. Our differences cannot be resolved. The question is, I want to live separately from my husband. And she also said that the provision of Section 9 is to compel a wife or husband to stay with a person with whom she is not interested to live and to resume cohabitation or resume our conjugal life, live under the same roof and the same bed is unconstitutional, and it affects my right of personal liberty. Also, Article 20, 21, 22 also was laid down. And a person was a revolutionary as far as the judicial process is concerned. It was the bench was presided over by Justice P.A. Chowdhury. Justice P.A. Chowdhury wrote a judgment striking down Section 9 of the Hindu Marriage Act, saying that it is unconstitutional, it shall not remain in the statute book. But of course, Mr. Venkata Subbaya was clever enough. He didn't stop at that. I don't know whether he had real affection for his wife or not, but still, he went up by way of an appeal to the Supreme Court. But please remember, the Supreme Court in its judgment mocked at the judgment of Justice P.A. Chowdhury and said Section 9 has been laid down with the sole objective of preserving the matrimonial life of the respective spouses. What is the use of the Mangala Sutram and what is the use of the Saptapati which is performed and other rituals that are performed in a marriage? And please remember, the oath which you take before Agni is to lead a conjugal life, live within the same roof and the same roof in spite of difficulties and all. And they struck down the judgment of Justice P.A. Chowdhury and said that Section 9 of the Hindu Marriage Act is perfectly constitutional. There is nothing wrong about it. So here the question is how a petition has to be filed. We will deal with it in the next class. That is tomorrow.
Question starts now.
Sir,
The question starts now. You can ask any questions for your questions. Please go ahead.
Sir, I'm Chandrasekhar from Hyderabad,
yes,
practicing Malkavgiri Court.
yes.
There is a doubt that a marriage is performed in a foreign country as per our Hindu ritual.
Right, right.
Which is Act, whether 1954 Act or 1955 Act will affect.
Sir, if it is done in a foreign country, it is normally under the Special Marriage Act of 1954, not under the Hindu Marriage Act.
Though, as per Hindu customary procedure,
Even if it is done according to Hindu customs, sir, most of our girls get married in the United States or in UK or something. But it's normally done under the Special Marriage Act of 1954 or as per the laws in America where Hindu customs are followed by a marriage certificate which pronounces them as husband and wife. The question is, even though all the I just take it for granted, all the formalities may not be completed, but still law presumes a valid marriage and is quite valid and enforceable also, sir. Then I know the next question which you will ask is where the divorce petition is. Please remember, marriage అయిన తర్వాత
no, sir, not like
you are అదే అయిపోయింది కదా సార్.
Only my next question is, if the couple have been registered at USA after marriage, as per the procedure at USA,
Yes.
they say whether they can register at India under section 1954, under section 8 of 1955 or 1954.
Sir, the question is it's registered in United States, let us say. But still, if you want to have the sanctity, because Indian courts don't recognize foreign judgments. Here you have to, whether you like it or not, based on that, you must ask for divorce or anything based on Indian law. We go section 13 of the Civil Procedure Code Foreign judgments are only obligatory. They are not mandatory. They need not be followed by Indian courts. Because in America and all, easy to get a divorce. They just on dotted lines you write, and one day you get your divorce. Not like India, we take years together to get a divorce.
That is why the children's father wants to
In
register
this,
at
since
India. He
you
wants to register at India under Hindu
చంద్రశేఖర్ గారు మీరు ఈ పాయింట్ రేస్ చేశారు కాబట్టి ఐ గివ్ యూ మై
Ah.
ప్రాక్టికల్ ఎక్స్పీరియన్స్ సార్ వన్ ఆఫ్ యంగ్ కపుల్ కేమ్ టు మై ఆఫీస్ ఐ టోల్డ్ ది గర్ల్ యు ఆర్ స్టిల్ యంగ్ ఇనఫ్ you live with your husband, how long your parents are going to live, please try to adjust with your husband. Then she said, sir, are you my father or brother to advise me? Take your chips and work, man. I said, I'm not bothered, I'm getting my chips, I'll work for it. అంటే తాడు తెంపంటే తెంపుకోండి నాకేం పట్టింది. But as far as possible, because please remember, marriages have become very, very artificial now. Thanks to the information technology or the IT, what is happening is the woman earns much more than what the male earns.
No, don't tell like that, sir.
So the question is, I've faced it, sir. I faced it also. I fought. Then I fought cases. Yeah, I fought cases of professors also, sir. The question of ego problem should not come in either of them. I'm not saying only females. It's also males also, sir. A male should not think that his wife is a subordinate or a banisa, as they call it in Telugu, right? Please remember, sometimes a male is not always right. Sometimes పెళ్ళాం చెప్పేది కూడా వినాలంటారు. తెలుగులో సినిమా కూడా వచ్చింది. The question భార్య చెప్పేది కూడా వినాలి, because sometimes she gives sane advices, but your chauvinism doesn't permit you to accept your wife's advice. You get into the ditch. So mutual adjustment, mutual compromise should be there.
చంద్రశేఖర్ గారు అన్ని ఇంటర్నేషనల్ కేసెస్ తీసుకొస్తున్నారు సార్. నిన్న కూడా ఇంటర్నేషనల్ కేసు మీద మాట్లాడారు.
Sir, yesterday my admin gave a problem, sir. My admin gave a problem. What I could judge is you are not yet equipped or adjusted to that problem. I'll give you 3 or 4 days time. Kindly answer that question so that your intellect also gets sharpened. Because please remember, like blah blah blah, I will be going on with my lectures as far as theory is concerned. How far it has entered your brains, how far you are able to assimilate, how you are able to understand, I should also know, isn't it, sir? There should be absolute interaction whereby each knows each other's capabilities, sir. And if any mistake is committed by you, don't feel shy about it. I'll correct it.
Any more questions, sir?
Sir, good evening, sir.
Yes.
Sir, I am
Vasant Rao.
Sir. Sir, in generally, second marriages, all rituals are not performed, sir. Hindu marriage act. Only the tying of Mangalasutra is sometimes happens. Sometimes they exchange the garlands.
Yes. Yes. That's what I said. Exchange of garlands is followed by the Naxalites and the radicals. Exchange of garlands and exchange of rings is done. And that is also presumed to be a valid marriage.
This is the second marriage, sir. That boy also got second marriage, and that's right.
Unfortunately, what has happened is the Supreme Court has struck down section 494 and 495 of the Indian Penal Code as it originally is the old Indian Penal Code. Bigamy is now abolished almost.
Sir, of course, sir. What happened in one of my cases, the wife married, my client married a man, and they get the certificate, a marriage receipt from the temple.
Right.
Whether it is a valid or not.
That's what I said when I discussed section 5. A person should not have a spouse living on the date of marriage. That is the reason they insist on a what is called a notice to be given. That is normally done in the case of Special Marriage Act. 1 month's mandatory notice is required before the marriage is registered. Even under the Hindu Marriage Act, if you want to get your marriage registered, 1 month's notice is absolutely mandatory. And at the time of presenting the application, if your earlier marriage has been dissolved by divorce or anything, you must file the certified copy of that to show that there is no marriage existing, no subsisting marriage existing. Then only it will be solemnized.
That is not question, sir. Recently, husband was died. And the wife married the second, who got the second marriage, got a file for partition suit. And the opposing them, there is no only servant file. There is no valid marriage took place between the husband and the wife. That's why the denying the only she's able to produce the only one. The man is the physique. Who get married before the court, they issue a receipt. So they're collecting the case. That is not the certificate. That is not a proof of valid marriage.
Right.
That is the difference. How to prove it?
The first question is, once there's a subsisting marriage earlier, the second marriage takes place by some more. Listen to
There
me.
is no substance.
If there's no subsisting marriage, there's no problem at all.
Then there is whether he is a servant maid or he is a wife. How can
Whatever it is, even a servant maid is also a mistress of the house. She can also become a wife. There's no disqualification.
Sir,
In Parsis, it is followed, sir.
She claiming the share in the ancestral property.
Ancestral, she doesn't get any rights. She is not a co-partner. She is not a co-partner. But her children get the share.
Children get share.
But she will not be entitled to a share.
But she has no children.
If she has no children, then it has to go to the next of kin, sir. That is according to the relationship.
The first wife's sons, children are there.
If they are there, they'll get it.
Okay.
Because if you see section 8, the class 1 heads. Class 2 comes only after when class 1 is not available.
All right, thank you. And there's one. We are meeting. We are trying to make a get together tomorrow at Hyderabad. As I circulated in the group. I have circulated in the group. Please mention that you are interested, not interested.
Before that, one question, sir.
Please.
Regarding nomination, what the sir has said, as per the bank rules, the nomination is mandatory, right, sir? And if the person is not willing to give the nomination, that is not possible. He is forced to give the nomination. And the nomination has to go only in the name of family members. Other than family members, it is not possible. So in such a case, can he write a will in support of the nomination?
Sir, he can substantiate it or corroborate it by way of a will. But as far as your version is concerned, it should be only family member. It should not be an outsider. It's not correct. I'll give you an example, sir. I'm, of course, not among Hindus. Among a particular community, I don't want to name that community also, that mostly the servant maid is the mistress of the house. And ultimately, the benefit is given to the servant maid. Just because she belongs outside doesn't mean that she does not get any right. She gets it. But provided she is nominated. But if it's substantiated by a will, it's an additional document. Are you able to understand, please? But the question is, the legal heirs, whomsoever it may be, wife or children or whatever it is, they can always question it by saying, when we are available, it cannot be given to an outsider.
So instead of giving 100% to the wife, if you want to share it with the mother, father, or other family members, other than wife and children,
sir,
in such a case, what is the remedy?
అదంతా చేస్తే కూడా మన అడ్వకేట్లు ఎందుకంటే మనం లిటిగేషన్ క్రియేట్ చేస్తాం కదా. The question is whether he gives it or not. Please remember, the question is, once a wife is nominated, she gets the entire money. But the question arises whether the wife is a co-partner or not. If it's an ancestral property, the wife does not get it in a dwelling house. That is section 23 of the Hindu succession. ఏమండి? Okay. Next, sir.
All right. So please acknowledge me your. Vasundhara garu, are you coming tomorrow for tomorrow's meet, sir?
Sir, place and time for tomorrow's meeting, sir.
I'll give the place in this tomorrow's meeting in the group itself with the all the things. How many people are interested? Please let us know, because according to that I have to plan it.
Though I am interested, I am staying at home, sir. I may not come there.
All right. All right. Thank you, and I'll show you the. I'll let you know the place.
But whenever opportunity comes, I will definitely come to your office and meet.
Please do, sir. Please do, sir. Please do, sir. Venkat garu, short notice, but ఏంటంటే we are trying to make it first attempt. Let us see how many people will turn up. That is the reason. I understand it's a short notice, but still we are trying to do it. Maybe in second. 1 week prayer. Sam.
Prayer notice.
Prayer notice ఎవడైనా చచ్చిపోతున్నాను
Sir.
కదా.
Yeah, at least we have to plan the travel and all.
No. I am not saying no for it because we got the time for it. Tomorrow we have given that slot.
Okay. Next time I
Definitely,
make sure
Sam. You came alone from Bombay to meet sir. That was a very good thing. I appreciate you for that. I know that what you have done for us.
Yes, sir. Okay.
Thank you. I'll send you the address in the group itself. Strength చూసి నేను కన్ఫర్మ్ చేస్తాను. Well, let me see the strength of the people, then only I can confirm it because the first meet should not be a failure. All right. Thank you.